A very good evening to one and all present. I'd like to thank each and every one of you who are joining us today for this very special session that we have put together of View TV by Vijay Bhumi, which is the Clat Masterclass series. This is the first episode in the 5-episode series that we have of the Clat Masterclass series. During the session, you will also notice in the offer section, I will put up the link for you guys to join for the next week's session where we're going to be discussing logical reasoning. So make sure that you click on the link and you join us for that particular session. Without further ado, let's begin this session. It is my honor and privilege to welcome Asad on this session. Asad is from NALSAR Hyderabad, as all of you would know, one of the top-rated national law universities in India today. Along with that, when he was in college, he and a bunch of his friends founded Clat, and I'm very proud to say that even I used Clat when I was preparing for the Clat exam as well as for the IELTS exam. So thank you so much, Asad, for joining us today and for taking out the time to be with us and talk to us about how we should go about legal reasoning. So the topic for today is how to crack legal reasoning in the Clat examination. Welcome, Asad. Thank you so much for joining us today.
Yeah, thanks a lot, Kritika. Thanks a lot. It's nice to be here. It's nice to have students also join us.
Thank you. If I may just request you, could you maximize our pictures on the screen so that we can see, because I am seeing us in a very small sort of I hope everybody is able to see us and hear us. I hope our audio is clear. You can let me know in the chat section. Please make sure that you're asking us a lot of questions during the session. We will be taking questions at the end of the session. The format of this session is, first I'm going to be asking Asad a couple of moderated questions on legal reasoning preparation. At the end of it, we are going to open up this session for asking him questions related that you guys will ask us in the chat box. All right. So without further ado, let's begin the session. So the first question, Asad, to you is, I mean, as we all know, the Clat pattern has completely been revised this year. So firstly, can you please tell us that what has changed between Clat 2019 and Clat 2020 in the legal reasoning legal reasoning section?
Yes. Actually, before I come to legal reasoning section, so Clat is an exam that was started in 2008 because the Supreme Court said all the NLUs should be conducting one exam, basically IIT JEE equivalent for national law universities. And what used to obviously happen was that each NLU would conduct the exam, in a different year. So there was no common secretariat. There was nothing like that. And in the year 2018, towards the end, they realized, let's actually get a common secretariat and let's get all the NLUs together and let's conduct one exam. And the secretariat will continue, conducting exam every year. 2019 was the first time that happened, but it was too late for them to be changing the syllabus or anything. It was only after the 2019 exam that they thought, let's actually streamline this, because before that, what used to happen was each NLU, the organizing university, would conduct the exam according to their own wishes. So the pattern would be different, the questions would be different. That caused a lot of confusion. Now, coming to legal reasoning section, a few broad changes that were made. Number one, of course, there used to be 200 questions for 2 hours. So one had to solve 200 questions and you got 120 minutes for that. Now they've not changed the time. It's 120 minutes. Even now, it's 2 hours even now. But instead of 200 questions, there are 150 questions. So that's the first change. Now it appears as if the paper has been made easy because, the number of questions have decreased, but the length of questions has increased. So it doesn't seem like there is any substantial advantage there. Now with legal reasoning, it used to be a 25% component in the Clat paper. It's the same 25% component even now. So it used to be 50 questions out of 200. Now it's going to be whatever 35 to 40 out of 200, according to whatever the Clat decides. And to ensure that people understand how exactly the questions are going to change, they also released a few sample papers, 3 sample papers. So it seems like there are a few changes. Number one, of course, is that there is no prior knowledge of law that is required. An example could be that if you look at previous year Clat papers, the principle of law would be given as volenti non fit injuria. There was no definition of it given. There was just a Latin maxim that's given. And now voluntary non-fit injury is such a specific concept that is taught to students in the first semester of the law school, where they learn this in the law of torts. And if someone does not know what voluntary non-fit injuria means, then they won't be able to apply that to the given fact situation. And that caused a lot of problems because it felt like Clat expected students to have a lot of knowledge of law even before actually joining the law school. That is not going to happen, number one. Second is, there were many rules that were given as principles of law, but a lot of these rules were applied along with many other rules, exceptions, etc., which were not given there. So the same voluntary non-fit injuria thing, there's an exception called rescue exception, which is that if I'm trying to rescue a person, and while doing that, if I suffer any harm, then the other person can't take the defense of voluntary non-fit injuria. He will be liable. Now, this exception was not given, but it was assumed that the candidate would know this. So that is not going to happen in this year's class. So this is actually a very good, development, that the students now, the aspirants now, are not expected to know any or have any prior knowledge of law. And instead of single line or double line principles, students will now be given a huge passage of about 400 to 450 words, in which there will be a lot of law, legal principles. And that will be in simple words. There won't be any technical maxims, technical words. So any person who can read it, comprehend it, and then can apply those to the fact situations that are given, that is all that is required. So it seems like that specialization that the Clat demanded earlier, that is not needed anymore. So that's the basic change. One other small change is, instead of having individual questions, they're going to have one huge legal passage. And under that passage, there'll be 5 different factual scenarios. And those will be asked. And they're also not sticking to conventional topics such as criminal law or torts. There have been questions from taxation law or IPR or even constitutional law, current issues. In fact, the recent sample paper also had a huge question on Epidemic Disease Act or National Disaster Management Act. And that is obviously because of COVID, because these were in the news. So it seems like if you have a good knowledge of whatever is in the news right now, that helps you, but you don't need any specific knowledge anymore.
Thank you so much for that insightful, answer, Asad. Actually, you're absolutely right. I mean, this is definitely a very welcome move by the Clat committee that they've decided to do away with the legal knowledge in the legal reasoning section, because actually, it was really unnecessary. Like, I don't know, by testing your sort of mugging up skills of how well you know legal knowledge, how was it going to be an aptitude test? Because I'm sure a lot of students here know that this is supposed to actually be an aptitude test. And for you to actually figure out that how well are you suited to be in law school. So this brings me to my next question, that in all likelihood, as of now, from what we hear, the Clat is scheduled for August, which is close to about 2 months away from now. So what do you suggest? Like, at this point of time, when students are 2 months away from the exam, what should one's preparation for legal reasoning be like?
Okay, so the thing is, legal reasoning section being the largest of all the sections, it's quite taxing to solve. So the first things, an aspirant should have is the stamina to go through all the questions and answer all of them. Now, what happens is, obviously, an average person might simply lose the productivity over a period of time. If I have to solve 40 questions over 40 minutes, the first 20 minutes, maybe I have high energy. After that, I might lose out on that. So to build that, there should be a very good habit of reading. Again, I don't really recommend reading fiction because, of course, it's very interesting to, read Harry Potter, but Harry Potter is not going to come in the exam. So because of that, there should be a habit of reading quite a lot of non-fiction, be it law-based articles or history or politics or economics and things like that. And then once, you have that ability to read these passages, long passages, it'll be easier for an aspirant to read the passage that is given in the exam, understand it, and then apply those principles to the fact situation given below. Now, there are many things one could do. Of course, reading can mean a lot of things. So one thing that can be done is visit websites which specifically have law-based articles. Now, personally, I recommend something like the Wire.in or Scroll or Quint or even Economic Times or Business Standard or the Hindu or the Indian Express. Go to the editorial section and look at any article or any writing which is based on law. Anything that is discussing any law, viewpoints, or so on and so forth, so that one is acquainted to read, articles which are actually based on law, and is able to comprehend them without wasting much time, and then, and is also able to apply those principles to the fact situation given. So that is something that one has to work on right now. It's just about how well and how fast one can read and apply.
Question, I think, and this is a question also, some of our attendees are asking us, is that how does one start preparing for legal reasoning? So let's assume that someone decides today that they want to start preparing for legal reasoning. So what should their way be of how they should be presenting, how they should start preparing? What is the sort of material that they should be looking at? So if you could throw some light on this.
Okay, so the thing is that's one problem that students actually face right now, and that's because the kind of questions that Clat consortium has made now, no other exam has similar questions. So with other subjects, be it, for example, general knowledge, it's the same no matter which competitive exam there is, the current affairs are going to be the same. Be it data interpretation or critical reasoning, you could go to GMAT or some other subjects to understand how exactly those questions work. But with legal reasoning, the problem is that they have invented these questions. And we don't really have any other exam or any other material to fall back on, because now, even the coaching institutes now have to absolutely create these questions out of the blue. So it seems like there's quite a lot of dearth of material. But personally, I think the first, thing that the aspirants should be doing is enrolling in some mock test series by any coaching institute. Doesn't really matter which coaching institute though. But what matters is that they get adequate practice in such questions. Now, obviously, Clat consortium itself has also put 3 sample papers and several sample questions. So solving them is a must. But more such type of questions will have to be solved. So for that, enrolling in a good mock test series is a way ahead.
Yeah, I think I couldn't agree with you more. I mean, this is also something that I remember very clearly when I was preparing for the Clat exam as well as for the NLU Delhi exam. I mean, it's so important for you to keep exposing yourself to, all these different question papers, because you also realize after a point of time that, once you keep exposing yourself, you also, sort of get faster at it in terms of solving the questions. And second, when you do like a bunch of questions, you also realize that, the next set of papers that you do, you'll see a repetitive pattern in it.
That's
so I think that's what really gives you an edge over the others, because I strongly believe, and I'm sure you do, that this exam is also like a large component of it is also time management.
Exactly.
And you have to be as quick as possible to solve these questions. So, Asad, if there's one thing, and I think this will be really helpful for our attendees who are here with us today, that what does one keep in mind while solving a legal reasoning question? Like, if I were to ask you, when you see a particular question, what is that mental checklist that you have, that I need to look for this? Like, what is your general format that you follow while, you are attempting a legal reasoning question? If you can break it down for our attendees here.
Yeah, right. I do have a few sample questions for that. But before that, the thing is, number one mistake that a lot of people do is that they mistake legal reasoning for reading comprehension. Okay, you won't find the answers in the passage. I mean, in reading comprehension, at least in the passage, you might find the answers right there. If you're able to understand it, you might come out with the correct answer. Here, there is application. So you have to understand the legal principles that are given, and then apply that to to the fact situations that are given. So the first thing that you have to actually look for is look at any legal principle that is actually given in the passage. Now, it is possible that some context will be given to you, or it is also possible that several legal principles might be given. But there are certain keywords that one has to look for. Things like any. Any might mean any, or
Yeah.
some might not mean any. So these are keywords that you have to look for. If at all, for example, just to give you a random example, Article 3 of the Constitution is given in the legal passage, let's say, which says that Parliament may, by law, can create new states or merge states or change the boundaries of the state, alter the name of the state, etc. So it says Parliament has the power to create a new state. Under that, it says, provided that the President has recommended the bill to the concerned legislative assemblies for them to express their views, and those views are presented to the Parliament. Now, it looks really tricky for someone who is just reading this, saying, okay, I don't understand the rule that Parliament has the power to make a law, but then there is a thing called provided that, which is a proviso clause. So how do these work? Now, provided that or the proviso clause is only a conditional. It means that if you follow the conditional, you successfully satisfy the conditional, then you can invoke the rule that is given, the power that is given to the Parliament. So these are things that you have to really pay attention to, because these will be simple words. Provided that, subject to, or a non-obstantive clause saying notwithstanding this. So these are simple words, and the examiners have played around a lot in the Clat sample papers also. These words were of high significance. So when somebody is reading the passage, it's important to perhaps underline these extreme words, or to understand how a legal principle applies and to what scenarios it applies. And it's also, obviously solving a lot of questions will give this skill, that when you look at the fact situation, you'll be able to second guess what exactly the examiner wants from you. It is possible that they have drawn a box and say all the things that are within in this box fall under this case. But there'll be a fact scenario which will be slightly outside the box. And that is something that you have to recognize and realize what exactly is within the rule and what is not within the rule. Right? So that's a skill that can't come overnight, of course. It's something that, obviously, when you practice a lot and things like that, that's something that you get it. So, should I put up this presentation?
Yeah, definitely.
All right. So these are questions. Maybe if I can reduce. Okay. All right. So these are a few questions. There's just one passage with about 5 questions, and all we're just looking at slides, right? Okay. So we'll be looking at this one passage and 5 questions. Now this passage was given in the second sample paper, official Clat sample paper. Of course, officially the Clat notification says that each passage will be about 450 to 400 words. Now this actually was the smallest of all the passages, so I picked it up because I thought for someone who's just getting introduced to legal reasoning section, this will be slightly easier to solve. That's one. And this is mainly based on this judgment, which came out in the year 2017, a 9-judge bench of the Supreme Court for Justice Puttaswamy versus Union of India, which said right to privacy is a part of personal liberty under Article 21. You see, Article 21 says no person shall be deprived of his life or personal liberty. And then they also said there are 3 things in personal liberty. One, of course, is informational privacy, which is that any information that's private to yourselves is something that the government cannot dictate or mandate that you share with another person. So my biometric information, my information with regard to DNA or my iris scan is something that is private. Of course, Aadhaar has been also, in this picture, and the safeguards of Aadhaar have increased and so on and so forth. Then there is decisional privacy, a privacy with regard to taking of decisions, personal decisions, be it with regard to one person's marriage or anything, or the right to abortion itself is a personal decision that a pregnant woman cannot be forced to abort or not to abort by anyone. It's a decision that she has to take under Medical Termination of Pregnancy Act if the conditions are fulfilled. Similarly, spatial privacy, which is privacy of specific space. Whatever I do within my house, it's not something for the state to snoop in or conduct any surveillance. So this is right to privacy broadly. And this is a part of personal liberty, so right to privacy is a fundamental right. Now, before that, the position was slightly different, and it was on that position that this passage has been written. So I'll just give out a minute for all the students in the section to read out the passage, and then we'll go question by question. All right. So if you could all just take 1 minute to read the first two paragraphs, that's all, just the first two paragraphs, and then I'll explain what the first two paragraphs are, and then we'll also look at the questions.
I must tell you, in the meanwhile, Asad, we've been getting a lot of questions which we'll have to take.
Yeah, it's okay. We'll do that. All right. I hope, people are answering the question already.
Yeah.
So I hope you've already read the passage here. See, it's pretty simple, right? It says there is one judgment here, Govind versus State of Madhya Pradesh, and the constitutionality of certain rules, certain regulations were challenged. So what used to happen was Govind was a criminal. He was convicted, yes. But because he was convicted and after he was released from the prison, he was marked for surveillance, and the police were actually following wherever this guy went. So the Supreme Court said two things. Number one, it said that mere conviction in a criminal case does not warrant any form of surveillance. Any form of surveillance, and it means that there is almost an absolute rule. It is not restricted to certain forms of surveillance, any form of surveillance, where there is nothing else that gravely imperils public safety. Now, it's a very simple sentence, but there are many rules written inside this itself. Number one, it applies to any form of surveillance. That's the first. Second is, but the rule does not apply where there is a grave threat to public safety. So if there is a grave threat to public safety, the surveillance is valid. But if there is no threat to public safety, then the surveillance is not valid, any form. Then it says domiciliary visits and picketing by the police can only take place where there is a clear case of danger to security. Again, if there is a clear case to danger to security, there can be surveillance. These should not be conducted in case of routine follow-up after conviction or at the whim of a police officer. So these are the rules. Now, what I would do when I look at this question is underline these parts, just the word any, or the exception as to when surveillance can happen. And having read this, then I would go to the question to see if whatever fact situation is given to you, would it fall within the rules or would it not fall within the rules? It's as simple as that. So what is happening in the first case here? It says but this person Mangesh, he lives in Bangalore, was arrested a few times for petty offenses. Okay, then he claims to have changed his ways. He runs a small trading business. That's all fine. Now he visited Mumbai recently on work, and while he was in Mumbai, the police followed him around the city. And see, there are many hints here. It should gravely threaten security. But here they've clearly given you that it was only for petty offenses. So there's clearly a hint that these people are giving you, the examiner is giving you, look, this is not as serious as an offense. It does not gravely threaten public security. So now the question is, would he succeed if he says that his fundamental rights have been violated? And it's pretty easy to conclude, yes, he would. And the reason is again the same thing, because his petty offenses or his past record of petty offenses is not sufficient to say that there was a threat to public safety. So the answer here would be A. which I guess most of those
A lot of people have guessed that. Yeah.
have already got it, right? Okay. Now, based on the same passage, let's look at the second question. Okay. You don't have to read the passage anymore because the passage is the same. Just read 1.2, everyone. All right. So, what is happening in this case is there is this person Rita, and she was expecting a judgment on a very important case involving religious issues, and she said if the judgment is not in her favor or in the favor of her religious organization, then she's going to burn the city to the ground. And that is all that you have to judge right now. If burning the city to the ground is a grave enough threat to public safety or not. And the answer is yes. Right? So now the question is, will she succeed if she says that the police have violated fundamental rights? And the answer will be no. So the answer is C here. No, since her statements showed that there was a possibility of threat of public safety. So you see the difference between the first question and the second question. The first question, there are clear hints given to you saying they were for petty offenses. He changed his ways. He was there for business, and then the police followed him around. That was a surveillance that was not required. Here, there was a record. She was being involved in communal riots in the past, and then she's issuing this threat. So an extreme case altogether. So two very easy questions, and pretty easy to say that the first one is not within the surveillance box, but the second one is, right? Okay, moving on. We have 5 questions in total. This is the third question. All right. So look at this. It says, which of the following, if true, would be a strong argument opposing the decision in the Govind case? Now, Govind case says you can only have surveillance if there is a threat to public safety. So what is a strong argument against that? Which means that there should be surveillance generally, not only when there is a threat to public safety. A says the police often monitor the movements of past convicts when they do not have any other leads. Now, this argument is not helping anyone because simply because the police does not have any other leads does not justify them monitoring movements of past convicts. If they don't have any other leads, then perhaps you don't even file charge sheet because it's not a crime that can be proven in the court. B says records show that once a person is convicted of an offense, they are highly unlikely to commit another offense. Now, this is only going against, in the favor of Govind case, right? Because if a person has been convicted of an offense, and if such person is highly unlikely to commit another offense, then why even monitor him if he's unlikely to commit an offense? If he's likely to commit an offense, perhaps then you might want to monitor. So not B either. C says conducting surveillance on a person ensures that they would not commit an offense which threatens public safety, against public safety. Another part of that is being hidden right now. But I think it says which threatens public safety. Okay, against public safety. So now this, if you realize, would actually be a strong argument because if, let's say, a person has the police is monitoring a person and there is surveillance on that person, and if that ensures that he will not commit an offense against public safety, then it is all the more needed that we actually monitor such people because there are no offenses against public safety. Perhaps because there is no I don't know, a terror attack or communal violence or caste violence, etc., which actually threaten public safety. It's desirable that surveillance happens to avoid such offenses. So the answer here is C because it will be a strong argument. Now let's also look at D. It says the government should not place any restriction on the fundamental rights of citizens. Now that's, it's a very general statement. It's not helping either of the arguments. So D is something that can be cancelled out straight away. So the answer here will be C. Now moving on. Now, see, this is a very good example for question which would not have been asked in the previous class.
Yeah.
That's because it's very critical reasoning based question, but on a legal passage, which is saying what is a strong argument. Now, this is not judging whether you have the knowledge or not. This is simply judging if you have the ability to think on these lines and see what is the argument that you would, further as a lawyer if you have to go in against the Govind case.
So, Asad, if I may just interrupt you here. So, since we're doing these questions, I think this is also a good time to ask you this question. A lot many times you see that, while you're attempting a question, so there are two options which completely don't seem like, they can be the probable answer, but there will be two which are very close.
Correct.
So what is the sort of way that you use to sort of, quickly navigate your way through that situation? Because, when a student writes the Clat, this happens like, across sections.
Correct.
So what is your way of doing it? If you can, you could just do it while solving a question for them.
Exactly. So let's look at the second question here. If you look at the option, A says no, B says yes, C says no, D says yes. Now, even if you've decided no is the answer, then one person could be confused between A and C here because there are two options with no here. One, of course, is look at the justification. The one that is justifying better is the answer. But one thumb rule that every person will have to remember is that the option that is substantiating the answer on the basis of legal principle given, that will always be the correct answer.
Correct.
That will always be the correct answer. There has to be a legal reason that should be given. So in this question itself, A says no since the day of the Supreme Court judgment was fraught with communal tensions. Now that is completely a fact-based thing to say that that particular day was fraught with communal tension. We don't really care if that day was fraught with communal tension. We have to see here what is the what is the behavior or what are the activities of Rita here. So, and that has to be justified on certain legal principle. And C is correct because it says there's a possibility of threat to public safety. And the legal principle given in the passage is about public safety, whether there is public safety or not. So, a very easy way to cancel out the other option is to simply look at the reason and see which option is justifying the answer that is given on the basis of legal principle given in the passage. So, yeah. All right, let's look at number 1.4 here. See in the chat if anybody is getting this. Kushi Jain is asking, are we expecting questions of the same difficulty level? Kushi, I don't have very good news on that front for you because you'll be expecting questions which will be slightly more difficult than the ones that you're solving right now. Okay, I'll take other questions in a while after we do these two questions. So 1.4, you see what is happening here. There is this person, Munir. His phone calls have been tapped by the police and they're listening to all his conversations for the past year. Now, he says that this violates his fundamental right. Now, police claim is that, look, he's a known criminal and the Govind case does not cover phone tapping. Here is where, if you realize, I was actually emphasizing the word any form of surveillance, okay, a lot. I told you that Supreme Court actually ruled that it does not, mere conviction does not warrant any form of surveillance. So it need not be physical surveillance where you are following a person or monitoring a person's movement, but it can also actually be phone tapping could also be one form of surveillance. Keeping an eye on a person's messages or his friends group might also be another form of surveillance. So this is also one form of surveillance, and all you had to pick here was an option which says that this is actually one form of surveillance. And if you look at it, there are two options which say no. Will the police succeed? The answer is no. A and B. A says since the police was planning to conduct domiciliary visits, that's again whatever the police was trying to do. That's not a legal justification here. The answer will have to be based on the legal principle that's given in the passage. It's B because since phone tapping would constitute surveillance, because this is straightly applying any form of surveillance principle to this. So again, apply the legal principle that is given, and mainly because if you don't apply the legal principle that is given, then there's no point of giving the passage at all in the first place. The passage is given to be applied, and that's something that you have to do. Okay. And the last question in these series of questions, please read this. Okay, so the question is pretty simple here. It's only this much that Pallavi was arrested and then she was also released on bail. And all the court did was the court asked Pallavi to report at the nearest police station every week to ensure that she has not absconded, she has not escaped from the, sort of like not surveillance exactly, but from the purview of the police control. So the question is, will this amount to violation of fundamental right, the requirement that she has to go to the police station every week and report? And that will not, because again, this will not really be, surveillance, because nobody is monitoring her movement, nothing. This is as a part of the criminal trial, and this will be perfectly fine. So she will not succeed. And there are two options which say she will not succeed. One, A and B. A says no, since the condition is imposed by the judge and not the police. Again, you realize this reason has nothing to do with any legal principle that is given there. The legal principle does not say it is okay if the judge imposes it, it's not okay if the police imposes it. No. So there is no distinction between that. So it has to be B, which says since requiring her to report to the police station once a week does not constitute surveillance. So this is one of the easiest passage, and this is actually one of the easiest sets of legal reasoning that we actually looked at, because, and I did not go for a larger passage because the text would not even fit in one slide, and then it would only this thing. So, but the thing is, if you're applying for Clat, you might have also seen that once you log into your official Clat account, there are Clat sample papers. So you could, give it a shot and try solving all the sample papers that you see. Right? Okay.
So, there are a couple of questions that we've had from our attendees on, for example, vocabulary, as well as, the importance of increasing your reading speed. Because like we are seeing, right? So these are very, very content heavy passages. At times, students might face difficulty with the vocabulary that's being used, or they might face difficulty with the fact that they have to read so much information in one go. So what are the tips from your side that how students can tackle with both of these issues?
Okay, so one general exercise that might help you is this, that go to any websites that I've told you, let's say the Wire. Just go to the Wire and you'll find the law section. Go to law. Now, of course, a lot of people might frown upon my mention of Wire because it's a little left-leaning and anti-establishment and all of that. But barring that, if you just simply go to the Wire and look at the law section, there'll be several articles that have been written by either law students or lawyers or academicians. And these are not politically charged articles. These are articles which explain a legal point of view. The best thing that you could do is perhaps open 6 such articles, give yourselves about 90 minutes of time, read one article properly, keep your laptop or whatever phone aside, try recalling that article in the same order that you've read, from start to finish. Just try recalling it, close your eyes and try recalling the same article. Now this helps with 2 things. Number one, it helps your obviously concentration and focus to read one entire article in one go. That is the stamina that you'll develop. Second, of course, is that when you have the pressure of recalling this article, you tend to remember whatever the article says. And you have to remember whatever the passage says, at least for the next 5 minutes till you solve all the questions. So you do that. Now, the other part about legal vocabulary or legal terminology is this, that the more you read the law-based articles, the more easier it will be. So, of course, it's difficult for somebody simply to understand words like even surveillance, which I'm not pretty sure if in normal, simple English would you even use words like that. will simply say a person is snooping, or a person is keeping an eye on another
Yeah.
person. Surveillance would be a technical word.
Yeah.
So for things like that, the more you read, and whenever you find a difficult word, jot it down in a notebook, write down the meaning, understand how it's exactly used, and things like that. This is how you improve. But the good part is nobody is asking you the word of that in the questions. So from the context itself, it's pretty easy to understand what that word means, and you'll never be given any such word which is too technical. So to give you another example, there was a question on privity of contract in the first sample paper, and the doctrine of privity of contract was explained there. So even if a person does not know what exactly privity means, or to be privy to a contract means, the explanation was sufficient to understand what privity of contract is. So just have some confidence that you will be able to understand the word in the context given, even if you do not know the literal meaning of the word otherwise. Right?
I think that's a very valuable input that you're sharing with our students here. So, this is another question which I also wanted to ask you, and I'm so glad the students who are attending this session are also asking you. So, when it comes to timing, how much time do you think students should allot to the legal reasoning section while they're attempting the CLAT paper? And I also have a follow-up question to that, which is that in your mind, do you think there is an ideal time that a student should spend on a particular question?
Okay, so it's going to be really messy if a person says, I'm going to spend 1 minute per question, because then you'll be looking at your watch every minute, and about 5 to 10 seconds will only go away in you panicking, saying the time is running out. But I'll say, if let's say the CLAT, the legal reasoning section is about 37 to 38 questions, it is likely to have about 38 questions. I'll say 40 minutes is a good amount of time. Don't really exceed 40 minutes. Try to finish it in 35 minutes, but you can have 5 grace minutes also. 40 minutes is a reasonable time. Now, if you're towards the end, maybe you've read the last passage, and then you've solved 2 questions, or 3 are left or 2 are left. And if you think that if you have another 2 or 3 minutes, you could finish that off as well, then finish it off. But if you've already reached 40 minutes and you have 2 passages left or 3 passages left, I'd say that you shouldn't be wasting too much time on legal reasoning section, because every question is of equal value. Then it's ideal for you to jump to the next section, and only towards the end, if you have time remaining, that you should come back to the leftover legal questions. But don't really go by 1 minute per question, because that is going to only cause a lot of panic. And this tension that you take, that the time is running away and you have to hurry, that is not going to make you very efficient or productive. So you might perhaps say, for the next 20 minutes, I have to solve 4 passages, 20 questions. I'll look at the time after I solve 4 passages, perhaps.
Yeah. So, there's another very interesting question that has come up in the chat box section, which I think, is very pertinent to this discussion. That, like you mentioned in one of your earlier answers, the CLAT consortium has given a passage related to the Epidemic Act. And constantly we've been noticing that CLAT has given other current legal passages too. So do we have to read or get some rough ideas about some legal acts that are relevant to the current situations internationally or nationally? Would you recommend that they go through these acts? Or probably would you recommend a particular website where they can sort of just go through the summary of these acts, which are, highly debated today? So, what is your take on this?
Yeah, I definitely would do that. So whenever you read the newspaper, whatever you see in the news, if there is any mention of an ordinance or a law that is being passed, make sure that you read a little bit about it. You don't really have to open the act itself and read the sections, but at least go to websites like prsindia.org. PRS India, there's a website, prsindia.org. And they summarize all the pending laws or ordinances that are being passed right now. For example, there was a recent ordinance that was passed to amend Epidemic Diseases Act, and that is because the government wants to increase the punishment or have punishments for people who commit crimes against healthcare workers. Yeah. So that's a specific thing. And what is the fine and what is it? That is something that you have to do. Now, this is something that you have to do anyway for the GK section, because it is possible that the GK section might ask questions like, okay, so what's the maximum punishment, or who are covered as healthcare workers and things like that. So this might be asked. But if you understand the provisions of it, then nothing like it. And this actually happened quite a lot where I was teaching about in the month of February or March itself, when when the COVID thing was, the lockdown was, it wasn't declared yet, but it was about to be declared. We had discussed National Disaster Management Act, etc., and Epidemic Diseases Act as well, because it was in the news. And it so happened that in April, when Clat released the third sample paper, they had one passage on force majeure clauses of contracts in the context of COVID. There was another passage similarly on Epidemic Diseases Act, etc. So that actually has quite a lot of relevance. So I think it's really beneficial for you to read up on this. But again, the same suggestion I made, right, to go to these websites and read the law-based articles. Once you read these articles, you'll automatically be acquainted with all the ongoing issues. So no special effort will have to be made for that.
So, Asad, like you said, like how, like for this year, the Epidemic Diseases Act or the National Disaster Management Act are going to be very crucial. And, they're likely, we can see that there are going to be some likely questions on these acts in the GK section as well as the legal reasoning section. Apart from these two, can you think of some other, current legislations from the top of your mind? Do you think that will be very crucial in this time's Clat paper?
Yes, it's definitely. In fact, there are recent, judgments also. There was one judgment in this case called BK Pavitra, which said, which spoke about reservations in promotions. So can you have SC/ST reservations in promotions? It says if there is quantifiable data, then a state government can have something. So an excellent passage can be made on that. There can be one passage that can be made on giving permanent commission to women in the armed forces, in all three wings of the armed forces. So something can be on that as well. There are ordinances also, and there are acts also that have been passed. Arbitration and Conciliation Act was amended last year, and one particular amendment was also held to be unconstitutional by the Supreme Court. There was a case called Hindustan Construction Corporation. So things like that. As in, if you follow the recent judgments and if you follow the recent laws, passages actually can turn up from any of these topics.
So, apart from this, Asad, as students, we have a lot of questions. So while everybody keeps telling us that it's so important for yourself, for you to constantly expose yourself to different kind of sample papers, different kind of questions. So, where can students look for these questions, right? So one, you suggested that, you probably sign up for a mock series with, one of these coaching centers. Then the second is like, for example, the 3 papers that, Clat themselves have released. Apart from that, if you were in their place, where would you go around looking for questions?
This is actually quite unfortunate, in fact, because we, honestly have a dearth of material here. We don't really have enough sufficient material for the students to practice. And that is mainly because the sample papers were only released in February and March and April. And the only people who would now produce such questions is the coaching institutes. And they also have not been able to supply the questions to the extent of demand. So that is one issue that has been happening. And for this year's Clat, this is an issue that students will have. They won't really be able to find questions that are of that nature. Perhaps over time, we will have enough institutes create such questions and put up all these questions in public domain that we might not have problem maybe next year. But this time we do have that problem. So I'll simply say this, that if you think that you have already covered the mocks of one particular coaching institute, you could explore another coaching institute.
Yeah.
Okay, because the only scope, it seems like the only window right now is coaching institutes who are generating such questions. Other than that, we really don't really have any scope of getting more questions from anywhere else, right?
So, Asad, at this stage, when these kids are preparing for the Clat examination, a lot of them, are also struggling with the fact that do we practice legal reasoning every day? And if we are practicing it every day, then how much time in a day should we reserve to legal reasoning? Because obviously at this point of time, tensions are mounting. There's also, there's immense anxiety. And now with COVID, it's obviously grown manifold and multifold, if I'd say. So, if you could throw some light, should they be doing legal reasoning questions every day? If they're doing it every day, how many questions or how many hours should they put in for legal reasoning? Should it be a timed exercise, for example, so that they improve their timing of solving questions? Something on the strategy, the preparation strategy side.
So the preparation strategy will obviously depend on each aspirant. I mean, in the sense that if a person, let's say, is very good with data interpretation but not so good with English, then they might have to focus a little more on English and read up a little, and vice versa. If somebody is good with data, with English but not so good with data interpretation, then you work that way. But with regard to legal reasoning, I'll only say this: it's okay not to solve questions every day. Solve as many as you can. That's perfectly fine. Perhaps you could solve about 10 questions or 15 questions. But it is more than that is important that aspirants read, law-based articles. That is something that you really have to be used to. And you can't, take a chance and be like, I'll go to the examination hall and I'll understand the passage, once I read it. That's not going to really happen because it's going to be very hectic. So if you're used to such passages and you read a lot of it, then perhaps. So in terms of preparation, one routine that is really helpful right now would be to read. Make your schedule properly. I'll simply, I recommend this quite a lot. Over your day, make about 4 or 5 2-hour slots. It depends on, if you're a morning person, you could start at, 5 o'clock in the morning and be like 5 to 7 is one slot. Then go for a run and then do something, and then 9 to 11 can be another slot or something. But have 2-hour slots, have 4 or 5 such slots. And in those 2 hours, you keep your mobile away, you keep your computer away, you keep everything away, and you focus for those 2 hours. Yeah. And in those 2 hours, it's possible that you keep one slot for reading law-based articles. And there's no dearth of such law-based articles at all. You can simply go to a website like Scroll or Quint or any such website and then read, open about 5 or maybe 10 law-based articles and read one after another and try to recall right after you read each of these. And perhaps that'll help more than anything. I mean, that is something that'll help you more than anything. And it's all about consistency. You could do this today or tomorrow. You won't really find any difference. But if you do it over perhaps 10 days or 15 days, then you'll notice that it's easier for you to read, this particular the passage that they might give in the, in the Clat.
So, we have a lot of friends who are joining us here who have questions on, they have just sort of decided, probably just taken the decision of writing the Clat and giving the law a chance, as a career option. So a couple of them are asking that, do you think this is a good time to start? Do I have a shot? So what would you say? Do they have a shot or not?
I think everybody has a shot, and that's the problem. I mean, if you're starting right now, I think you're really lucky. The problem is if you've been preparing for 2 years, then that's a bit of a problem, because now you have to change gears, and it might be a little, I don't know. People who have been preparing for 2 years, who've been topping their mocks in their coaching institutes, they have seen a drastically, a drop in their scores because they could not take this, and they obviously did not take the changes well, etc. If you're starting now, I think it's a clean slate for you, so you can start off immediately. Start reading, start solving questions. There is everything that you need right now, and it's possible. It's possible to crack Clat with 1 month preparation as well. But of course, again, I guess accident of death. It depends on where exactly. What's your starting point? Also, if somebody has been reading quite a lot in their life for the past 5 years, if you've been reading the newspaper, properly, or if you've been following the news properly, then Clat might seem like, okay, this is a simple exam because I just have to read things and then answer. But if you're starting something altogether now, if you have never read the newspaper, you've only read the headlines maybe, or you're following In Shorts app, instead of reading long form articles, etc., then you might have to put in a little more effort. But it's doable. There is nothing to be disheartened about. It's doable. It's definitely doable.
No, I totally agree with you. And I think I must share here, I'm sure even Asad agrees with me, in both of our batches, for me at NLU Delhi and for Asad at NALSAR Hyderabad, we all know of our friends, who have said that, they started preparation only after the board exam got over, which was literally a month and a half away, from the Clat. And those people ended up doing really well and made it to the top NLUs. So I totally agree with you. For our friends, who are just starting preparation, guys, don't lose heart. You should definitely just get into it. But now that you're getting into it, please put your heart and soul into the preparation. And I think the strategy that Asad has shared, that you make these 2 hour slots along with ample breaks in between, but make sure when you're in that slot, you're totally in the zone and completely free of all distractions. I think that is great. That is really a must, and that is what's going to take you a long way in the CLAT exam. The other thing that, like another question that's been coming up, so, a lot of students also have apprehensions that with the entire COVID situation, there is a chance that the exam might be an online exam and it may be a remote proctored exam. Like, as I understand, this has also happened with the LSAT this year, that the LSAT has become an online exam and remote proctored exam. So, do you think students should sort of keep that in their mind while they're preparing, that this can be an eventuality? And if this were to be an eventuality, then how should I sort of, incorporate some techniques so that I become comfortable with giving a computer exam?
Okay, so personally, I'm very anti online or computer exam, and I'm pretty sure, that CLAT is not going to be online. There are a few reasons. Number one, of course, is that CLAT has had very bad experience when it was conducted online in the years 2015, 16, 17. Some computers would not work, some would work, etc. Now, LSAT, Symbiosis, Christ, this year they have come up with AI-enabled exam where you sit in your own house, and then there is a AI software which tracks who is around you, so that there's no cheating, of that sort. And then the exam is conducted. Now, with CLAT, I don't really think that's feasible, because in a country where I don't know, less than 5% or 4% of the households actually own a personal computer, I don't think it's fair, even constitutionally, to have an exam where you could only take the exam if you have a computer and a good internet connection. That is not completely fair. So I don't think it's going to happen. Even though CLAT has taken, they have conducted a survey asking if students would be okay with online exam, and overwhelmingly the results have been that the students were not okay with the online exam. Now, having said all of this, there is a 0.1% chance of the exam being online. You could basically, now that you'll be reading a lot on your computer, on your screens, develop the stamina of sitting at one place, and read for about 2 hours, just in case the exam turns out to be online. But be really hopeful that it's not going to be online. But otherwise, if it is online, then I think that also can be tackled. It's a disadvantage for everyone, okay, because not many people would be it won't be comfortable for a lot of people to take the exam either. But hopefully, it will not happen. Is what I'd say.
So, Asad, there are also a lot of questions on, cutoff. Like, personally, I feel that without, seeing what the paper is going to be like, I think it's very difficult to sort of gauge what the cutoffs is going to be and what you should aim for to get into the top 5 NLUs. What do you think about that?
Okay, so the cutoffs have been drastically going up and down. So, for example, a paper like 2015 or 14, which was really difficult, it was enough to score about 130 out of 200. Last year, a paper, the 2019 paper, was extremely easy. So people had to score about 165 to 170 out of 200 to make it to make it to top colleges. So the cutoffs don't really matter as much as the ranks. Now, however, if the sample papers are any criteria, but even in the sample papers, there's quite a lot of variation. The first sample paper was slightly difficult. The second one was quite easy. Third one was slightly difficult again. If you go by the third sample paper, I'd say for the top 5 colleges, the cutoff will be anywhere between 121 to 123 or 124 out of 150, taking into consideration the negative marking and all of that. But again, this is something that obviously I have no authority to speak about cutoffs, because it'll depend on how exactly people find this exam. And it seems like the competition has also increased quite a lot. And with all these extensions, people who've been thinking of NEET or people who've been thinking of IIT, they're also obviously, they see that law is an option for them as well. And they might also apply. Now, it was somebody only yesterday was telling me that the Clat had crossed 1.5 lakh applications. Now, that's quite a lot, considering last year barely about 60,000 people, 70,000 people took the exam. So 100% growth, or like the doubling of this is, which it will mean that the cutoffs will obviously go up, because the competition is quite high and the number of seats has not really increased. I mean, in fact, it has only become worse, I must say, because of
with the
all
reservation.
reservations, and NLS has got 25% reservations. NALSAR
Yeah.
already had 20% reservation. Anyway,
NLU Delhi this
50.
time. Yeah.
So I mean, it's becoming a little, I don't know. The state governments are I don't know, competitive federalism, I guess, but they want their students there because they're putting in a lot of their resources in NLUs, which I slightly understand, but it's also wrong for it's sad for those students who come from states which might not have those excellent NLUs.
Exactly. Yeah. Because there is a varying difference in the quality that one sees.
Exactly, and what if there are several states which don't even have a NLU, and that also creates quite a lot of
Yeah.
issues. But so it seems like it's a little unfair, these domicile reservations, but irrespective, that's what it is. So just, I mean, you just need, each of you needs simply one seat. If you get that one seat, why do you care about the domicile? So just focus on that as well.
Yeah, now I think it's important to also discuss, some questions related to the mental frame of students. Now, there are two questions I have in this aspect. The first is, what has happened is right now with this entire COVID situation, there are so many students who have been, preparing for 2 years or 1 year. Now, because of which what has happened, because of this uncertainty, the fact that it's getting, extended, even right now, we are slightly unsure whether it's going to happen in August or not, depending on the coronavirus situation in India. So obviously, students also tend to lose interest, in preparation. So how do you think should those students cope up with this, situation that they are in? And the second question that I have is during the exam, like, so because it's just 120 minutes, and while you're there, obviously the pattern has changed. There might be some surprises that are thrown at the students. So you might just get very panicky. It can be very nerve wracking. So how do you deal with your nerves at that point of time? So if you can answer these two questions, I think it'll be very helpful for the students here.
Yeah. So the first question, I'll just say, everyone should read about the pale blue dot about by Carl Sagan. I don't know if you've heard of this, but there is, just Google this after the session, something called the pale blue dot. It's essentially a photograph that was taken by Voyager from almost outside the solar system of the Earth, where the Earth actually looks like a very small dot, which means that that's the planet that we live on. So, I mean, to simply say that as a rule in life, actually, generally, that you shouldn't worry about things that you don't control.
Yeah.
And things become really easy if you have that approach saying, do I control this? Do I have the power to change this? If you don't have that power to change it, if you can't control it, then you don't really have to be tensed about it at all.
Yeah.
So ask yourself this question, do I have the power to ensure that Clat happens as soon as possible? No, none of us actually do. We don't really know what is going to happen with COVID-19 situation at all. But nobody else has that power either. So you're just one of those, people. It's not like you are powerless or you are vulnerable. No, you're just one other person. So don't think of things that you can't control. Now, second is, it's very normal for any human being to have these bouts of productivity, and suddenly there's a depression. That I might be really productive today, motivated today, but after 2 days, my energy will obviously come down. And for that, you need some substantial targets. So make a weekly timetable. If it's today's Tuesday, think of what you want to do this week. Have a weekly timetable. Things like, what are the targets that you want to achieve by this Sunday? How many mocks do you want to take? How many readings do you want to do? How many questions do you want to solve? Divide that into so many number of days, and every day that you finish your targets, that itself is your motivation. And trust me, like when you do it for like 2 or 3 days and you successfully finish the targets that you have given for yourselves, you feel so motivated that you'll actually automatically finish the target for the fourth day as well.
Yeah.
But if you don't have those targets, if you don't have those milestones, right, then you'll feel like you lack sense of direction. You feel like you're just going around aimlessly doing things, simply waiting for some certainty to happen. So
Yeah.
in the face of all this uncertainty, it's important that you create your own mini certainties, and then you chase those on your own without thinking of when the Clat might happen or when exactly that might do. That's one. Second is, during the exam, your approach should be one question at a time. The moment you think of like 150 questions, When you think of like, okay, I have to solve 150 questions, and you won't really be able to solve it because I'll be solving question number 1, but I'll be thinking of 149 other questions. And I'll go like, you know what, I have 149 more questions to solve, so let me hurry up. For every question, you'll do the same thing and you'll mess up all the questions that there are. So when you're reading a passage, the passage is right in front of you. There are 5 questions under that. Focus on simply reading that passage and answering those 5 questions. And whenever a thought crosses, as to like, oh, there are 145 other questions apart from these 5, tell yourselves, I'll come to those later. For now, my priority is only solving these 5 questions. And if I do well, I'll go to the next set of 5 questions. And you go passage by passage, question by question. It's very easy because you'll be fighting 150 very small battles, but you'll be winning like a huge battle of 150 questions that way. So you do that, it's a better thing, it'll be easy on your brain also.
Yeah. So, there's another question. A lot of, students have this question that till what month do you think they should prepare current affairs?
Okay, that very unfortunately, Clat has not defined that. So much so that there have been questions in the Clat sample paper. They asked about Battle of Koregaon Bhima. The Battle of Koregaon Bhima happened in 1818.
Yeah.
And that was relevant because on the 1st of January 2018, a lot of Dalit groups, Elgar, Parishad, etc., had commemorated 200 years of Battle of Koregaon Bhima. The Marathas lost and the East India Company won, mainly because of the Dalit army that the East India Company had. So it seems like if you simply, there are 2 perspectives of it. One perspective would be like, why did you ask a question from 1818? But they're not actually asking question from 1818. They're asking question from something that is relevant today.
Correct.
The Battle of Koregaon Bhima is something that is commemorated every year. And after the violence that happened in 2018, in 19 and 20, it was commemorated even more in a grand manner. So that is something that's relevant. So I don't think there is any time limit that one could prescribe, but it seems like it's beneficial to go back 12 months from the month of Clat. So if Clat is going to happen, let's assume it's going to happen in August. So start from July. I mean, obviously you can't do July current affairs right away, but start from June right now and then go back at least 11 months. So it's beneficial, Clat minus 12 months, do the 12 months, but be ready for questions which might be 2 years old as well. It's possible that they might ask questions like that, but just know this much that, you simply have to pursue excellence, but you can't reach excellence.
Yeah.
Okay. So you can't know everything anyway, but the more you read and the more you revise, the better for you. That's all there is. So you have a lot of time. You all should go and then do past 12 months of current affairs, and then just hope for the best that most of the questions might end up from these 12 months.
Yeah, thank you so much, Asad. I think we have covered largely most of the questions that people have asked us.
Right.
Because I see a lot of people have asked us that whether they should be covering each subject on a daily basis, and I think you have answered that adequately with your 2-hour slot schedule. So I think that answers the question very well. Thank you so much for joining us today. I think it's truly been an honor, and it's been a very informative session. I mean, I really, hope that, I wish that, when I was writing the Clat, I could attend a webinar like this where there could be so many tips and tricks that could be discussed, around the preparation, around the paper, and, how, what kind of a mental frame you must be while preparing or taking the paper. So thank you so much. For all of our attendees, thank you so much, guys, for joining us. It's truly been such an enjoyable session. So many questions, very, very engaging for us. I will request all of you that this is a 5-episode series. This is episode 1. In the next episode, we're going to be dealing with the logical reasoning section, where we'll have a different speaker who will join us on how to solve questions of logical reasoning. Likewise, the week after that, we will be dealing with GK, we will be dealing with math as well as English. So make sure that you guys join us. This is going to be happening on every Tuesday at the very same time. So please make sure that you're connected with us. Thank you so much, Asad, again. This was truly, truly amazing. I hope you had as much fun conducting the session.
Thanks a lot. Thanks a lot for that. I in fact did not even realize that we are well beyond 1 hour. So that actually, shows that the session was actually fun. So it was fun talking to you. Quite a lot of relevant questions, and your inputs are also quite valuable. In fact. Okay,
Thank you so much, Asad. And before I part, I must tell you that, we just ran a poll right now and 100% of our attendees thoroughly enjoyed the session. So this is all kudos to you. So thank you so much, everyone. Stay safe, and we hope to see you next week when we discuss logical reasoning and critical reasoning section in the CLAT exam. This is Kritika Padode signing off on View TV. Thank you.
Thank you.